but there are some real problems ahead, I think, in disability discrimination law. Physical or mental impairment is something there's been quite a lot of movement on recently, particularly with the European case HK Denmark and the consequences of that. Until recently, the test as to whether or not the cause or effect of a disability was to define whether or not someone was covered under the Act was that you didn't really have to distinguish between the two, but that both were important. I'm going to talk now about HK Denmark. This was a European case handed down last year. Its reference to the United Nations Convention on the Rights of Persons with Disabilities should be an indication now to employment lawyers that we need to look not just as far back as the European directive when we're looking at the origin of rights under the Equality Act. We need to go even further back and look now as well to the United Nations Conventions on the Rights of Persons with Disability, physical or mental impairment, how one is to interpret that. And secondly, the other thing that we looked at very briefly, the question of activities, what activities need to be affected. To define the scope of the directive by reference to the cause of the disability would be arbitrary and would thus be contrary to the very aim of the directive of giving effect to the principle of equal treatment. So it's pretty clear from that sort of sentence that the idea that you look at the cause of the disability appears, looking at this case, to be contrary to the aims of the directive. Now, that means, in my view, that domestic law as it stands at the moment is incompatible with European law. It makes a clear distinction there between the Americans with Disabilities Act and the idea that HIV can be a disability if it's asymptomatic, and the European idea, which is based on the effect of whatever the impairment might be. Until reasonably recently, a day-to-day activities was one that was normal for most people. And this is the current guidance, paragraph D9. Normal day-to-day activities do not include work of any particular form because no particular form of work is normal for most people. And it gives an example: a highly specialised skills or levels of attainment. A woman plays a piano to a high standard and often takes part in public performances. She develops carpal tunnel syndrome in her wrists and can't do it any longer. That is not, in accordance with the present guidance, a normal day-to-day activity and a disability.
The protected characteristic that I'm going to be talking about, as I said here, is religion and belief. And effectively, I'm just going to have a quick look at some of the decisions from the last 12 months. Just included a quick reminder of Section 10 of the Equality Act, which gives very bare guidance as to what may amount to religion and belief, but doesn't really indicate what is going to be classed as a religion. And the first case I'm going to talk about is rather topical this week. For those that saw the news on Sunday, England had their first legally valid Scientology wedding in a Scientology chapel. It was a case involving whether a Scientology chapel was classed as a place for religious worship. The focus, of course, in this case was about where places should be recorded for the purposes of marriage, and therefore Lord Tolson was keen to exclude the secular from that decision, whereas, of course, Section 10 is wider because it brings in as well philosophical belief. But what I think this definition may help in the future is at least to say, well, if it falls within this, then it should fall within Section 10 of the Equality Act, even if the reverse isn't true. I simply refer quickly to this ET case as a reminder that, of course, the protection under this Act is not just for the major world religions. Recently, a discrimination claim on the basis of being Wiccan was upheld. And turning to the following case, which concerned harassment. Now, those of us who are in tribunals every day, I think, become somewhat immune to the foul language that may be present. What was said in this particular case across the Times newsroom was, "Can anyone tell me what's happening to the fucking Pope?" Now, that formed the basis of a harassment claim by a Roman Catholic who overheard this and was upset and offended. You can see there that Mr. Justice Underhill, as I've quoted at the bottom, said, not only was this not ill-intentioned or anti-Catholic or directed at the Pope or at Catholics, it was evidently not any of those things. And that was why it was found not to amount to harassment. But I think it's also interesting that it's perhaps, Mr. Justice Underhill says next, is perhaps a reminder that employees and claimants can't be overly sensitive about their religious beliefs. And I've quoted there where he's saying that perhaps in an ideal world this shouldn't have been said, but that effectively doesn't make it something for which legal liabilities should be imposed. And Mr. Justice Underhill was very clear that the tribunal was unarguably right. I'm going to turn now to what may amount to a philosophical belief as the other half of this protected characteristic, as it may be. Now, I've put a reminder here of the guidelines given in the case of Granger, which will be well known to those that have dealt with the question of what may amount to philosophical belief. But the first to be considered in the matter of Olivier was democratic socialism. So putting everyone on the spot, who thinks that that does amount to a philosophical belief within the Granger guidelines that were listed in that case? Well, those that were brave enough to put up their hands are right, according to the Employment Tribunal in this case. Simply membership of a particular political party is not sufficient to gather protection under the protected characteristic, under the Equality Act. What was particularly relevant here was that the belief behind why this claimant had joined the Labour Party, namely his genuine and strongly held belief in democratic socialism, was sufficient.
A brief recap. Article 6 of the Framework Directive provides justifications of differences in treatment on grounds of age. A possible get-out-of-jail card, because although there is an absolute prohibition on discrimination, in our case on grounds of age, there are certain things that mean that we will not be discriminating. So let's see what those things are. The context is important. In the context of national law, if differences of treatment are objectively and reasonably justified by a legitimate aim, we may escape the reach of Article 6. Well, what's a legitimate aim? The directive itself gives us some indications. It talks about legitimate employment policy, labour market objectives, and vocational training objectives. Now, if you are able to bring yourself within Article 6.2, you are able to completely escape the reach of the age discrimination prohibitions. And so it's an important provision, hasn't been scrutinised by the CJEU up until now. Now, in Christensen, the employers operated a pension contribution scheme where the percentage contribution made by the employer was related to your basic salary and was graduated with reference to your age. Unsurprisingly, perhaps, that was considered to be discrimination on grounds of age, prima facie. the government attempted to avoid findings of liability for age discrimination by seeking to rely on the exception in Article 6.2. It sought to argue that the pension scheme that it operated was akin to an occupational social security scheme. It covered the risks of old age, and therefore it invited the court to find that it fell within the scope of the exception and no liability could possibly lie. But, the court said, first of all, looking at the language of Article 6.2, it is clear that it applies only to occupational social security schemes. Those are schemes that cover the risks of old age and invalidity and things that are associated with that. There is nothing about this pension scheme, the court said, that makes it look anything like a scheme that Article 6.2 was intended to encompass. And they gave the suggestion that the 6.2 exception applied very short shrift indeed. There is a provision in police pension regulations which allows the police authorities to effectively compulsorily retire certain individuals who have reached a specified rank, provided only that on retirement they are entitled to receive a sum equivalent to 2/3 of the average pension payable to police officers. Riveting, I'm sure you will agree. What the police authorities had done amongst a number of forces across the country was to agree a systematic approach to how they would seek to meet the challenges of reducing budgets as a result of the comprehensive spending review. This was a case where there was no argument about whether there was prima facie discrimination. It was an indirect age discrimination case, but it was conceded that the employers had applied a PCP which was prima facie discriminatory, so that the only way out was for the employers to justify the application of the policy or provision. The justifications that had been proposed or floated related to force efficiency. The employers, as I say, having obtained counsel's advice about what justification might be legitimate, didn't actually then go and gather evidence to see whether or not the justification that they thought they could rely on actually stacked up in practice. So whilst they were arguing quite strongly that imposing this rule would bring savings in costs, they failed to identify, as the Employment Tribunal rapidly did, that the effect of this policy in terms of budgets was very limited, because most of the officers who were eligible to be compulsorily retired would retire in any event. What the tribunal said was that there should have been detailed consideration by relevant decision makers in relation to the proposed justification arguments. At those meetings, evidence about the alleged effects of the measures that were proposed should have been rigorously considered and scrutinised. The tribunal was very, very keen to criticise insufficient, critical, rigorous evaluation of justification arguments. It, in the nicest possible way, suggested that respondents would be better spending their money not on counsel's opinion as to whether or not justification was made out, but gathering the evidence, looking at it for themselves, and taking a view in the light of the conclusions that it drew.
Can I ask if anyone has any questions for any of our speakers? We've got a few minutes.
I think I'll just have to repeat that slightly for the purposes of the recording. So it's whether the context, as it were, the difference between a building site or a more genteel environment might make a difference. And actually, I perhaps should have said this was actually one of Simon Cheatham's cases originally at the Employment Tribunal when it was done. And we had a very interesting conversation earlier about it, actually, because that is precisely what was so important in this case, was that foul language was generally used quite a lot in run up to deadlines. We can all imagine it, that there's a lot of pressure, and so it wasn't a context in which foul language was, say, unusual or particularly maybe regarded as offensive. And I think what that case is particularly good at showing is context is everything, and that's to do with also the way in which, the reason why something's said. So here it was very much taken that it was an inquiry over where a newspaper story about the Pope had been delayed. And it wasn't a comment on the Pope himself. It was very much about we're on deadline, where is the empty, the article to fill the empty page. So it very much was context is everything in that case, and the particular circumstance in which that was said.
There'll be drinks upstairs in a moment. Just to prove how passé I am, I've only just watched the first series of Borgen, so I think we say tak to Joe, and we say thanks to Spencer and to Ros, and perhaps we could give a round of applause.